All right. Well, I think we can get started. Hello, everyone. My name is Paul Bierman. I'm the Director of Education and Events for MBNA. Welcome to today's webinar, Estate Planning Tips for Business Owners. Thank you to the Education Committee for their work in putting this webinar together. As an MBNA provided webinar, this webinar does offer education credit for the Certified Memorialist program. Your attendance is recorded and you will be able to claim your credit when applying to become a CM or to maintain your certification. Before we begin, I have just a few pieces of information. Please hold on to your questions until Will has concluded his presentation. And if you need to step away for any reason, this webinar is being recorded and will be available free of charge to MBNA members via the MBNA website. With that being said, today's presenter is Will Creech, CFP, Vice President at First Citizens Bank. I will now hand things over to Will.
Thanks, Paul, and good afternoon, everyone. Again, my name is Will Creech. I am a wealth planning strategist for First Citizens Bank, and I am based out of Raleigh, North Carolina. I've been with the bank for about a little over 3 years now, in the industry for 10. So my role as a wealth planning strategist is to get to know clients, get to know their goals, identify what long-term their financial goals plan is, and with that, understanding their financial goals and plan holistically, whether that be cash flow, retirement, risk management, their investments, their legacy goals, estate goals, which we're talking about today. And we take that and project it over their lifetime. And we also stress test their plan and look for efficiencies and maybe ways that we can restructure and do things in a little bit more of a clean way. So super fun topic on a short week. Well, short week for us, Tuesday. You're probably going to get sick of me talking about what happens when you die. But like Ben Franklin said, death and taxes are certainties in this life. So we're going to address that head on today. Like Paul mentioned, I'm a CFP, so Certified Financial Planner. I have my master's degree in financial planning from the University of Georgia. So now that I talked about all the things that I am and am going to do, let's briefly touch on what I'm not, and that is a attorney or a tax professional. So we're going to be discussing some high-level estate planning tips today, and certainly recommend you take what bits you have today and take them to your tax professional and to an estate planning attorney. There's a lot of great attorneys out there, but for business owners, certainly recommend when you talk about estate planning, finding an attorney who specializes in estate planning. Because when you add the business owner concept in there, it does add some complexity. So just making sure you're working with the right professional in that space is key. So the agenda today, we're going to talk about some critical tools in estate planning. We're going to do a quick overview on what a buy-sell agreement is and what that means. We're going to look at a brief case study and talk about what action items we can start taking. And then we're going to leave a few minutes for some question and answer segment at the end. I don't know if we'll go the full hour today, but I will try to keep us on pace as best I can. So those of you who were with us in our last webinar, we talked about the 3 legs of the stool. This is primarily geared towards business owners, being the personal, financial, and business. So the personal leg of the stool talks about separating us as individuals from our business owner persona. So as business owners, we find that clients' identity gets wrapped up in their business. So if you are looking at an exit, what life looks like post-exit, we find a lot of times clients don't clearly identify what that looks like. So for example, people don't realize how much time they work in their business and then they phase into retirement. And then sometimes people don't realize how much time they're going to be spending with their spouse or what their goals are with all that free time. They're going to play golf. They're going to spend time with their grandkids. But what does that actually look like on a sustainable day-to-day plan? And have they written that down, articulated that? So on the financial side,
Sorry, Will.
Yep.
We're not getting a full screen share on your PowerPoint.
Okay. Let's see. Does that do anything?
So I think if you just click the slideshow button down there towards the bottom right-hand corner, I think that'll probably um, switch it over.
So it's going into slideshow mode on my side. Let's see. Bear with me 1 second. No, it's not doing anything, huh?
Nope, now we're good.
Oh, we're good?
Yep.
Okay. All right. Jumping back in. Sorry. On the financial side, if we're looking at retirement, do we have the means to retire and transition from the business, or what do we need out of the business to accomplish those goals? Or do we have a number in mind for what we need? And that carries into the business. So, do we have a wealth gap? Do we need to close that wealth gap? And that transitions into, is the business value there? Do we need to grow the business? What are some steps we can take with the business to increase to decrease the value gap to close those financial goals? Um, so estate planning kind of runs into all three of these in a different way, um, because the idea of the estate planning is being prepared in the event if something happens that we aren't foreseeing, right? So let's jump into the important estate planning tools, starting with a will. So a will is the basic document that is really essential for everyone. It's going to define where your assets pass to, and it's going to be a probate process. So it's going to go through the courts. So with the will, we have the healthcare power of attorney, the financial power of attorney, and the healthcare directive. So the healthcare power of attorney is a person who you appoint to make healthcare decisions when you are unable to do so. So the reason why this goes hand in hand with the will is a will only it becomes effective at death. So if you are incapacitated and still alive, your will is not going to kick in. So we've got to appoint someone to make those decisions for us when we're unable to. So with the healthcare power of attorney comes a healthcare directive. So healthcare directive is also known as a living will, and that's essentially lays out a guideline of what your desires are if you are in an incapacitated state. So it touches on life support and different things like artificially keeping you alive, all those kind of fun conversations that we love to think about. But it gives some of a roadmap to the person who you appoint the healthcare power of attorney. So you don't name someone a healthcare directive, you name them the healthcare power of attorney, but the healthcare directive gives a guidepost on how that is supposed to shake out. So the healthcare side of it, and then there's the financial power of attorney. So this is a person who is allowed to act on your behalf for financial transactions, whether that's buying and selling real estate, buying and selling stocks, signing checks, balancing your checkbook. It appoints someone to that person. So the will, healthcare power of attorney, financial power of attorney, healthcare directive are what's known as core documents. So again, these are essential for everybody. And then when you're having these conversations, I would definitely recommend, first off, appointing someone in those positions that you trust, which kind of goes without saying, but I would also encourage you to have 2 or 3 backups in the event that something happens to one of those people who you've named to act as an agent for you. They can step in at a moment's notice. So if you don't have these documents, A court has to appoint one for you, and I don't know about you, but waiting for a court to appoint that person in a medical emergency does not sound like something that I'd want to wait for. But it's the reality of not having these documents in place. So moving on to the revocable trust, we'll get more in depth, but the revocable trust, the benefits there are going to be some control and flexibility. It's going to help keep things out of probate, and it's going to add a layer of privacy. We'll kind of talk about what that means here in a second. And it's got the ability for incapacity protection, where it allows someone to step in and manage your affairs in the event that you cannot. The buy-sell agreement is going to be really for business continuity. It's going to ensure that your business is able to operate in the event that you can't. You have a triggering event that requires someone else to step in. Defines the ownership and transfer, and it protects the business and stakeholders from the business falling into ownership of people we may not intend for it to. So this is what's called intestate succession. So this is a little bit of a good news, bad news situation. So good news is if you don't have documents in place, the state that you live in will have a plan for you. The bad news here is I've yet to meet a single client who has wanted to go with this route or likes the plan the government has for their assets. So this is just based off of the state of North Carolina. It's just a good visual. So let's just hone in right here on spouse with 2 children. So in the state of North Carolina, if you have no will or no documents, and you're married and have 2 or more children, a third of your real estate is going to go to your spouse, and then $60,000 of personal property is going to go to your spouse, and then 50% of any more personal property outside of that will go to your spouse. So then 2/3 of your real estate would go to your children, and then 50% of your personal property above $60,000. And as you can see, there's different sequences the state of North Carolina has laid out for individuals who die intestate. So again, they are plans, but typically they're not plans that people like, especially business owners, right? Typically, business owners like to have a little more control and thought to what happens with their property. So that is with property that goes into your estate. So let's talk about property that passes by contract. So what does that mean? So let's use a life insurance policy as an example. When you buy a life insurance policy, you name a beneficiary. So no matter what your will says, or no matter what the state says, if you're intestate, that life insurance policy will flow to your beneficiary. And the same is true with bank accounts that are POD. The same is true with retirement accounts that have beneficiaries. And then if you have a property in trust, it does not follow this path. And there are several, first off, encourage you once a year to take a look at this property that passes by contract, whether it be beneficiaries on life insurance policies or retirement plans or bank accounts. Because going through this, I've found several times where there's been ex-spouses named where they weren't supposed to. So a good rule of thumb is at least once a year to check on your beneficiaries, just to make sure they're currently in line with your estate plan. Because like I said, if you can say in your will that you leave everything to your spouse, your current spouse, but if you have a beneficiary of a life insurance policy you haven't looked at in a while that names an ex-spouse, it's going to go to the ex-spouse. So once a year, let's just take a look at our property that passes by contract. Also, another one I would hit on, if you're unmarried and have no direct relatives, your estate would what's called escheat to the state, which means the state would take control and ownership of those assets. So a lot of times people would rather leave their property to like a charitable event or a friend or family, a distant family member. So always important to check on these things. And if you have no plan, there's one for you, and you probably won't like it. So let's talk about what a will is. So a will is going to name the executor of your estate. And it's going to provide for the payment of any debts or funeral expenses that you have. It's going to appoint guardians for any minor children, and it's going to dispose of your property. So it's going to ensure that all your wishes are followed. It's going to designate those key roles. It's going to be the simple and most cost-effective way to dispose of your estate. And a well-drafted will can minimize probate delays. And if anyone out there has been an executor of estate, you kind of know what I'm talking about. It's very time-consuming and it's a cumbersome process. So what are the shortcomings of a will? One is that probate's required. So that means it's going through the court. The court's going to have um, jurisdiction over it. It's going to become a public record. So any nosy neighbors, family members, business partners can actually go to the courthouse, petition to get your will, and it's going to be in a public record. And just as proof of that, you can go look right now and pull up Elvis's will, which he did not have a fantastic estate plan. So if you want to, I guess, an example of how not to do things, then you can pull up Elvis's will. But like I mentioned earlier, if you just have a will and don't have those other documents, there's no incapacity protections. So if you have all your money in a bank account that's got your name on it and you're incapacitated, it's going to be difficult for someone to help pay your bills. And then in a business owner sense, something that I've seen that we just want to make sure that we have in mind is had a business owner who became incapacitated and didn't have their articles of organization up to date. So they were the only signer on the business bank account. Something happened to them and no one was able to pay bills or pay payroll or pay vendors. And it was a mess. So business continuity is kind of the name of the game here, and making sure that we have these documents in order and have looked at them recently. So that brings us to revocable trust. So a lot of times I hear people say like, oh, I don't have enough, I don't need a trust. And some folks don't fully understand what a revocable trust is. So I always like to have this conversation because it does make a lot of sense for, I'd say, a majority of clients, and there are some huge benefits. So with the will passing your assets through probate, if you put them in a revocable trust, you can avoid the probate process and almost minimize it. In some cases, completely get rid of it. So it's also going to maintain privacy. So unlike the will, when you go through probate and it becomes a court record, anything in your revocable trust stays private and it can't be petitioned, and people can't come look through your inventory of your estate. A revocable trust can be amended at any time, and it's you. So it's not a separate entity. You can move assets in and out of it as you choose, and you've got complete control over it. It does allow for incapacity protection, so that if things are properly titled in your trust, you can name a successor trustee to step in and manage those assets on your behalf. So that makes for very efficient asset management. The downsides of revocable trust, so there's no immediate tax benefit because, like I said, it is you from a tax sense. It's got the same social security number, tax ID number as you. So there's not going to be any kind of tax benefits for setting it up. A rev trust is only worth the paper it's written on unless it's adequately funded, right? So you can have this document drawn up by an attorney and signed, but if you don't have your assets named into the revocable trust, then it doesn't do anything. And talk a little bit more of that here in a second, but there is a little bit more complexity and it is a little bit more costly, but it's a cost benefit, right? So if that privacy and efficiency is important to you, then I think that kind of outweighs the extra cost of setting one up. So let's just roll back to this slide for a second. So in an efficient setup, you have most of your assets tied or named in your revocable trust, and you would still have a will as a catch-all. And you might have heard this term, but you'll hear it called a pour-over will. So what that means is any assets that were not titled in your revocable trust will be caught by your will at your passing, and they'll pour over into your revocable trust. So when that happens, the assets that weren't in the trust do have to go through probate, but it's a much more abbreviated probate than all of your assets going through. So it's a very efficient way instead of having to wait. The average time for settling a trust is about 9 to 12 months. And with business owners, it can be a little bit longer, as well as it's a pretty, for those of you who have served as an executor, it's a very time consuming event. So those are the core like personal planning. So let's talk about the objectives of buy-sell agreement. So buy-sell agreement establishes a clear plan at a business owner's death how the shares and ownership of their company will transition. So they're usually based off of triggering events, which the 5 Ds, if those of you who recall from last time, which is death, disability, divorce, disagreement, and distress. So it's those 5 Ds and then retirement. So it protects the departing owner's estate, and it also protects the remaining owners by defining a clear mechanism for who is going to take ownership and control of the business, as well as establishing a mechanism for determining a value of the business. So um, it's going to protect the business. It's going to provide liquidity for the departing owner, whether it be death, disability, retirement, what have you. Defines who controls and owns the shares, and it sets a fair price. So what I found from doing this for a while is that I'd say most of the time clients, when they set up a business, they set up an operating agreement, and most of the time it hasn't been looked at since that original operating agreement. So for a buy-sell agreement, I think the statistic was 75% of business owners haven't even looked at it or haven't updated it, and the risk you run there is the value that's defined in the operating agreement has usually changed over a period of time. So the value of the business has usually gone up a pretty substantial amount since the business was actually founded. So making sure those mechanisms are still in line with your current estate plan are hugely important. So if you haven't put your eyes on your operating agreement, I would strongly encourage you to set up some time with your attorney to review that and make sure your buy-sell agreement's in place as well. So there are different types of buy-sell agreements. So the main ones are going to be your entity purchase or a stock redemption buy-sell agreement or a cross purchase. So an entity purchase is when the company itself is required to buy the shares of a departing owner. A cross purchase is when you have multiple business owners, let's say business owner one and business owner two, they've entered into agreement where if business owner one has a triggering event where they either pass away or become disabled, business owner two is required or has the first right of refusal to buy those shares. So the other common one that we see a lot of times is called the one-way buy-sell. And I actually have a pretty good example of when this has been put in place here recently. I had a client who she was a widow and owned a engineering firm. So she had a son, but he was not an engineer. So it's kind of hard for a someone who's not an engineer to take over an engineering firm. So what she did, she had a nephew who was an engineer. So we set up a one-way buy-sell agreement. And what that means is if something were to happen to my client who was the engineer, the company bought a life insurance policy on my client, and the beneficiary was her nephew. So if something happened to her, the nephew received the life insurance policy and used those assets to buy the business, which means the money from the purchase would go to our client's estate, which would leave her son the liquidity from the business that she was running. So it's kind of a win-win-win there, right? So the company continues on, has a good owner. Nephew didn't have to go get a loan to buy the business, and then client's son was able to get the proceeds of the if God forbid something happened, wouldn't be out of luck with all of mom's liquidity tied up in the business, right? So a lot of times business owners do have most of their net worth tied up in their business. That's just the nature of being a business owner, right? So just demonstrates the protection there, and having a plan in place to make sure that son was taken care of, business continued to operate, clients were taken care of, key employees were taken care of. But it doesn't have to be relative, right? So sometimes people set these arrangements up with a competitor. They set them up with key employees, and getting into kind of got ahead of myself a little bit there, but insurance is one way to do it. So the other key options is a sinking fund, which is basically establishing a pool of money to set aside for a triggering event. Um, the other option is an installment loan or a company finance loan. So someone comes in and then they use the profit of the business to eventually repay a note or an installment loan. And then the fourth would be setting up a sale event and having someone either find financing outside or whether it's a private equity firm or they have the cash, what have you. So we're looking at ways to protect the key stakeholders, protect the business and its employees, and set up the next person for success in the event that it's um, like not a third party, it's a family member, friend, colleague, what have you. So in that situation, we're protecting against death, but then also we want to look at ways that we can protect against a voluntary withdrawal. So that's just I'm walking away, I'm quitting, or I'm ready to retire, or a disability. But also with the buy sell agreement, we want to fund against or we want to protect against ownership of the business going to a party that we may not want to be in business with. So, for example, let's go back to my client here. Let's say she didn't put this in place, and now we have a person who is not an engineer trying to run an engineering company, and now his inheritance is online. Key employees may be looking for other jobs or unsure about what their job security situation looks like, and also we have existing contracts that may not get finished. So um, by failing to plan, we're planning to fail in a sense in this situation. So put together a little bit of a case study, and Legacy Monuments was just is a random name I came up with. If someone out there has a Legacy Monuments, this was not intended to replicate anything that you have going on specifically. But in this situation, so James is 58 and he's married and he's 60% owner of Legacy Monuments. It's a tombstone manufacturing company that's organized as an S corp. So he built the business with his business partner, Mark Miller, 25 years ago. So Mark's a minority owner, 40%. But James has 3 children. So Emily, Michael, and Claire. Emily and Michael are active in the business on the operational side. And Claire is not. She's outside the business, doesn't have any interest in owning it. So James has no estate plan. The operating agreement was established when the business was founded, but hasn't been revisited since. So James and Mark have loosely agreed on a contingency plan if something were to happen to James, but there's been nothing documented on paper. So, like I said, Emily and Michael are involved in the operations, but don't have any direct management experience. Claire lives out of state and works in a different industry. She has no interest in working for the company. So what are our risks here? So if James has no estate plan, who inherits the shares of the business? So it's going to be a little bit of a combination between James's wife and his 3 kids, who all in total have 60%. So they can, if they work together, they can control it. But if not, we're kind of in a mess. So if Emily and Michael are getting equal shares, who kind of fills the leadership role in that power vacuum? What happens to Claire? Claire doesn't have any interest. She has ownership of a business that she never wanted, but how do we make her whole and how does she get compensated like her siblings do who are actually working the business day to day? Is this business supporting the family? So if Michael and Emily don't get their paycheck, what's going to happen? And is James' wife dependent on the money he gets from the business? So who's going to support her? And then outside the family, what happens to Mark and what happens to these key employees that have worked with us for years? How are they going to be affected? So we're looking at, on the financial side, we're looking at some liquidity risk. How can the business buy these shares back? Does it have the ability to do that? What if James is in a situation where now estate taxes are due. How are we going to get money out of the business to pay those taxes? Do we have any protection strategies in place from a liability standpoint, from a retirement standpoint? Um, have we addressed these things? So on the business side, see this far too often. Um, do we have documented processes? So has James written down, how he does business, or if something happens to James, is there any clear direction? Was James the face of the vendor and supplier relations, or if something happens to him, where those key relationships are at risk because there was no separation between James and the company? If he was the face of those relationships, and key employees, if something happens to James, are they gonna, run for the hills and find some more job security somewhere? And what's that going to do to the business? And what are the cascading effects of not having these things in place? Whether it, like I said, affecting James's wife's stability, livelihood, and Michael and Emily paying their bills. So there's a lot on the line when we don't have a clear succession strategy for our business as far as a buy-sell agreement. So that leads us to the question: what can we start doing to mitigate some of these things? So these are steps that I would say, call it rolling implementation, where we can kind of accomplish them in stages, not necessarily one step at a time, but just taking it in bite-sized pieces. So James needs to sit down and first identify what his goals for retirement and succession look like. Does James want to work until the end, which is very common around business owners, or is James in a situation where he wants to start looking for an off ramp to start enjoying retirement? With that, if something were to happen to James, there needs to be a clear succession of who is going to fill what gap. Start documenting these processes and holding regular family meetings, because another thing that I've found too often is that, like, for example, James's kids, Emily and Michael, work in the family business because they feel like they're supposed to, and they kind of just feel like that's what they've always done. But taking a step back, if they were given the situation, um, dad's no longer here in the situation, I have the choice between selling the business and taking money, or continuing to run the family business, sometimes they would choose the money. So I found that a lot of times these conversations aren't even being had, and there is not much visibility between family members of what the direction is. So step one is really understanding what the goals are and what the family's goals are. And step two is working with your legal and tax professional and your wealth management partner to kind of implement this process. So, one, understanding what the business value is or what the gap is, crafting a succession plan with the proper funding mechanism, whether that be an installment note, insurance, that sinking fund, which the pool of money, and then taking a look at your asset allocation and risk tolerance review to take a look at your balance sheet and your assets to find out what is the best play. Because going back to Claire, for example, Claire's not interested in the business. Michael and Emily may not want their shares diluted by Claire. So what is a way that we can compensate Claire in a different way with not business assets to make, first off, the family stay whole, but also make sure we're supporting the business? So where your attorney and your tax professional come in is, number one, we're going to update and implement our estate plan. And a good rule of thumb is to have these documents looked at every 5 to 7 years. And that's if everything is completely normal going, nothing's changed. Anytime there's a big life event, whether that be a death, a new addition to the family, a marriage, divorce, that is a trigger point to look at your estate planning documents. We need to understand the tax implications and what a transition looks like. So if you're in a situation where you might have an estate tax, or what kind of gain would be realized from the sale of a business, we need to make sure we're understanding that, as well as the value of the business. Just like with your estate plan, your buy-sell agreement, an operating agreement needs to be revisited. That's done with the attorney. We want to take a look at our next level management and make sure that we have some proper retention goals or retention strategies. So whether that is maybe introducing a retirement plan, maybe um, letting key employees get a share, like a minority share of business to keep them engaged, but making sure we have those a plan for those that next level management, those key employees to stay in place. Um, and last but not least, if you were looking at any kind of gifting or transition strategies where that's uh, gifting shares to the next generation or to those key employees, or looking to um, one day give ownership to the next generation, we want to work with our legal and tax professionals to understand what strategies come in play and how those are going to impact us on a tax basis, and how that it plays into our entire uh, retirement and financial plan. So, going to leave you with a little bit of tax information. So, uh, in 2017, the last time Donald Trump was in office, he passed the Tax Cut and Jobs Act. So that on paper is due to sunset at the end of this year. So the feeling is that that will be extended, which would set the federal estate gifting limit at around 27 million. So what that means is, as long as your estate is below that threshold, you would have no federal estate tax due. But with that, no matter what side of the aisle, you tend to favor. Congress is not able to agree on much of anything. That hasn't been just this year. That's kind of been historically over the last several years. So they're going to have to come to some kind of agreement to get this passed. But from what we understand and what we're seeing, we do believe the Tax Cut and Jobs Act from 2017 will be extended. But until the legislation, the bill is signed, we have to live under the assumption that it's going to sunset at the end of this year. So with that, the way the law reads today, if nothing happens, the top personal income tax bracket is going to readjust to 39.6%, which currently the top tax bracket is 37%. The state exemption would go down, but the estate tax is going to remain fixed at 40%. So I think for a married couple, as it sits, if it were to sunset, instead of being 27 million, it drops to about 14 million. The standard deduction that was raised to 27,700 would be revert back to the lower levels, which I think was like 21,000. The QBI deduction, the qualified business income, is set to expire. The exemption for AMT or alternative minimum tax will revert back to the lower levels, and the SALT limitation, state and local government taxes would go away, and you'd be allowed to itemize your state and local taxes back on your tax returns. So this is a more of a point to make sure you're on top of what these changes look like with your CPA. So it's a good idea to make sure we have an understanding of what the value of our business looks like and what our balance sheet look like. Because some of the external factors that Congress is going to be talking about is our national debt levels, and how we're going to pay that. So there's got to be some kind of compromise somewhere. One would imagine, but until we have passed the legislation, we're not really sure what that's going to look like. So, like I said, that's why we're kind of taking the approach of it's almost March. We've seen some drafts come through, but there's been no real movement towards a new tax bill. So with that, going to wrap up, and I'd be happy to answer any questions you have. We got about 15 minutes or so.
Yeah, if anyone wants to ask Will a question, feel free to unmute yourselves and just ask it out or type it in the chat. Or if you'd like to keep it a little more confidential, if you want to direct message me, I'm glad to read it out for you.
Didn't realize I was not on camera. I apologize.
All right, Will, we do have a question here. Have you ever worked with an owner who wanted to create a cooperative and turn ownership over to their employees?
Yeah, so that would be like an ESOP. Uh, Certainly have. It's a complex strategy, but that is definitely more of a one-off conversation to get into kind of the weeds. I could do a whole presentation on that. So I'd be happy to reach out and kind of run through that with you and kind of talk more in depth about what that looks like.
Next one here. Is it possible for an estate to plan to finance a business transaction in order to pass on the income from the sale in the form of payments?
Um, so thanks for your question, Donna. Do you mean as far as you'd want the business to finance the sale and the your beneficiaries receive the income in a annual, semi-annual, monthly basis over time, and the business be the one kind of acting as the bank? But if I'm understanding correctly, certainly. Yeah, so that could be done. We'd have to work pretty closely in conjunction with the state planning attorneys and make sure we have the proper form set up. But absolutely.
Oh, we'll wait just one more minute here and see if anyone has any other questions they want to get in.
Absolutely. Thank you, Pat.
All right, well, with that being said, I'll echo what Pat said and say thank you, Will, for coming here and presenting today. I know this is definitely a topic that's at front of mind for many of our members. I just have a couple of things to say as we close out. First of all, if you enjoyed today's webinar, make sure to keep an eye on your MB brief for information on future webinars, both from the Education Committee and from other aspects of MBNA. I'll also say that we do have our 2025 Industry Trade Show coming up in March in Cleveland. So if you've not registered, please take a look at the website and see if you want to attend. I will be there, and I certainly hope many of you will be as well. So with that being said, that concludes today's sessions. Thank you for joining us and have a great day.
Yeah, thanks everybody.